All right. Hey, everybody. Welcome back. Another session of Due Process with Dads. Today, we'll be covering child support. So, I'm James Gunter, co founder and executive director of Present Pillars. I have with me Blair Johnson of Blair Law. How you doing, Blair?
Great evening, James.
Good evening. Before we start, I just wanted to bring a couple things to everyone's attention. We have a couple really cool things coming up. The first one I want to talk about is our spring expungement fair. It's on your screen now. This will take place March 15th at First Church of God in Benton Heights from noon to 4. So if you have any convictions or anything, any questions, we'll be able to answer your questions and help you process your application for expungement there or determine your eligibility as well. So if you need that, if you know anyone that needs that, please give that information to them. The next one is, of course, our dad group. So we were doing this initially. We kind of faded a little bit, but we want to come back because I see the need. So on Monday nights at 6 p.m., please feel free to stop by the Pillar Center. You could share your experiences, vent, get advice, everything you need right there in one spot. We'll have dads who are experienced, dads who have no experience. If you're thinking about becoming a dad, this is your space as well. So just wanted to share those things as we get started. And now that I have, it's all yours, Blair.
All right. Well, thanks, James. Good evening, everybody. Welcome back to Due Process for Dads. And as a highlight, so I'll be at that expungement fair, God willing, to help again. We did one in October at LMC, and I have to say I had the pleasure of just Tuesday working with a guy who came to see us at that clinic, and we got all of his criminal convictions, 6 misdemeanors and 1 felony, wiped out completely. So this is real stuff here, folks. We're not talking theory. We're talking about real change. And so definitely, if you want to come, the resources there are terrific. If it's like the one we had at LMC, you can, if you're not eligible, you can learn a lot about when you're going to be eligible, get your questions answered. And then even potentially, get some assistance in getting that process started. So tonight we are talking about child support, and we talked last week or last month about custody and parenting time and child support in Michigan, and kind of feeds right into that. As I said last time, Michigan, a little different than Indiana and some other states. Whenever there's an order for custody and parenting time, there has to be an order entered for child support, and vice versa. But if you start a child support action, there's got to be some provisions in that order for custody and parenting time. So jumping in, why is child support even necessary? And I think the key to highlight here is that the right to child support is afforded to the child and not the parent. It may not feel that way because the payer of support is paying the other parent, and it's totally out of his or her control what that parent is going to spend money on. But under the law, and the reason why child support in various parts of the Michigan statute was set up, is that it's a right afforded to the child, not the parent. And the language from the statute is the children have an inherent right to support from their natural parents. The purpose is generally twofold. It's one, to ensure that a child's basic needs are met, and two, to minimize the difference in standards of living between parent homes. So when we get in a little later tonight on a child support recommendation, we're going to see the way that it gets treated is as if the family unit were still intact, and you had parent 1, mom or dad, and parent 2, mom or dad, living together, that joint income was there and available to that child, such that when the parents are now separated, the income differential between the two households can be sort of evened out, not entirely, but you don't want the child going from one home of wealth to a home of poverty, or vice versa. Child support can be ordered in any number of cases, and those codes we mentioned last month. DM is a divorce with minor children, and this is when you have a case, your court cases 2024 dash certain numbers dash DM, DC, DP, DS, whatever it is. Each one of those codes represents a type of case and how it was initiated. So, and there's a bunch more other different parts of the Michigan code that child support factors into. But generally, it's divorce, custody, paternity, and support. It almost always requires, not always, but almost every single instance, that there's a biological or adoptive relationship between the parent and child that's been formally established. You can't be ordered to pay support for a child that you've not been legally connected to. And as a sort of a warning out there, support is so important that even in certain instances, if your rights have been terminated, you may still be ordered to pay support. Now, I haven't seen that happen in a lot of the cases that I've had, but the law doesn't terminate that obligation, even if the parental rights have been terminated. So what does or doesn't child support cover? There isn't any place in the law or a handbook that says it's specifically going to cover these things, but generally speaking, it covers basic necessities: housing for the child, utilities, food, clothing, education. It'll also cover health insurance expenses, medical expenses, and childcare expenses. Things that are not included in a child support order that could be additional or need to be addressed separately from that court order are, the big one is extracurricular activities. If your child is enrolled in, the big one is travel hockey, that's the most expensive one, then it doesn't cover the fees, it doesn't cover the equipment, it doesn't cover camps, any of that stuff. So typically in a lot of my cases, we'll have a provision outside of the child support order that says how those extracurricular expenses are going to be shared. It also doesn't include higher education. There's nothing, and I'm waiting for the day when our legislatures are finally going to get on board with the idea, that most kids need a college education. But right now it's not something that is ordered or considered in child support because kids are not kids necessarily anymore when they're going to college. Private education, tuition, that's not covered. Cars and auto insurance for your kid when they start to drive, it's not included. Cell phones and electronics, those aren't included as well. So how is it determined? I would imagine most people are familiar with the term, the Michigan Child Support Formula. If you're not, the Michigan Child Support Formula was created by the legislature in 1986 and went into effect in 87. And it's updated every 3 or 4 years. And most recently, actually, there was a new update at the beginning of 2025. That formula is required to be followed in every single case. It is legislatively mandated. Now, there are, exceptions and ways to not follow that order, but the majority of people who are paying support are paying support based on that Michigan Child Support Formula. And we're going to talk about what that is and what goes into that. I have on here, and you can Google it too, but the link is on here, the Michigan Child Support Calculator, the formula that is the calculator behind it. That was actually put on the web, I think about 3 or 4 years ago, so that if you want, you could actually, log in and put all your details in and get a fairly accurate number for what child support would be. In our county here, Berrien and the surrounding counties, the friend of the court will prepare a recommendation for you. You get them the information, they kick it out, and I'll show you what one of those looks like. In some counties and other counties, the parties themselves have to present what the calculation would be. Usually if they have lawyers, the lawyers will run the calc. Now, parents can agree to a different child support amount, and it can only be done by agreement. If there's no agreement, then the court's going to follow the child support formula. It requires the parties to cite what are called deviation factors, meaning, these are the reasons for not following what this formula says that we should do. Some of those factors include incurring additional significant medical or educational expenses if a child has special needs. Those might be a deviation, usually upward. Award of property. If a parent gets property and that may be in lieu of support, if they're getting like a home and not having to pay a mortgage on it, then that may be used as a basis not to order support. In some cases, a child earns an independent income, though I've never seen that happen. And bankruptcy is another one. There's about 26 deviation factors, I think, under the formula. And you can even look that up. You could Google Michigan Child Support Formula, and it'll take you to the page where you can see this whole thing of all of the rules and issues for what goes into calculating child support. Now, deviation is not available if a child is receiving state assistance, Medicaid, food stamps, WIC. And the reason for that we'll get into a little bit later, but you can't deviate if the state is in some fashion subsidizing the care and maintenance for your child. And just as a warning that waiving support in exchange for a parent agreeing to voluntarily not exercise parenting time is rarely ever granted. There are exceptions made when there's domestic violence. So the policy goals of saying what's more important here, that a parent receive child support, if at all, but that it be ordered, or if that other parent is, has domestic violence with the custodial parent, the court may opt not to order it because they just don't want to bring that person into the other parent's realm. In other words, the safety concerns override the income needs in a situation like that. What is or isn't considered under the Michigan Child Support Formula. So the primary data inputs for calculating child support are income, obviously. Income in the formula is very widely defined. Income is wages, it's tips, self-employment, disability, unemployment, military pay, distributions from any investments that you have. Income is basically anything that you have that's coming into your household in some fashion that helps you pay your bills. The other primary factor is the number of overnights between the two parents. And certainly as that number of overnights goes up or down, that child support amount is going to go up or down. We'll talk a little bit about that later. But those are the two major determinants for what a child support amount is going to be. Other factors include cost of health insurance. Some of that can be attributed to a child, and a portion of that can actually be either credited to or deducted from a payer's obligation to pay support. Daycare costs are an addition. Any daycare that you're paying, and this can be a huge one for parents of young children. Some portion of that can be attributable to the other parent, whether they're using that daycare provider or not. They can be ordered, and that has to be verified by a particular form, a child care verification form that the daycare provider completes and submits to the friend of the court. Birth and pregnancy related expenses, those can be added in, as well as additional minor children. If you have other children not in common with the other parent, you can receive an offset or a deduction in what that child support amount is going to be. What's not considered, the big one, is the bills that you have to pay if you are paying child support. The statute, the formula does not consider that you have a budget and you have to pay rent, you have to pay electric, you have to pay utilities. It doesn't consider whether or not you have to pay child support on this other case. And that's a big deal for folks because, at the end of the day, if the formula says they got to pay this, but they have these bills over here, the only way out of that is through a deviation factor. But it doesn't consider at all what the outgoing needs to meet bills are for the payer of support. Other things that are not considered in calculating child support for income purposes are if you're on SSI, means tested income, supplemental security income, that's not considered. income. Inheritances, one-off inheritances, it's not a regular source of income. I'll get to your question in a second there, Craig. Then also earnings by a spouse. So even though the household may have additional income from a spouse of another parent, of the other parent, that spouse's earnings cannot be considered in determining support. So Craig asks, when both parents request no spousal support or child support, what does Michigan do when the child will spend most nights with the father? Again, generally speaking, if the parties have an agreement that there's not going to be any spousal support, which is a little bit different than child support, or child support, then at least where I practice here, the courts will typically accept it. And that could be independent of the number of overnights. So if you're just saying, we agree we don't have a need over here for support, and we're not going to seek support from each other, again, so long as there isn't any Medicaid, food stamp, or anything like that involved, then the court should adopt your agreement not to seek child support. Now, like the issues of custody and parenting time, it's modifiable. Child support is modifiable based on a change in circumstance, meaning that if circumstances change, and let's say a parent has a job and that's why they don't need support, but then they lose that job, then obviously you've got to have the ability to come back in and say, well, now I'm in need of support because my income stream has been disrupted. So like all things related to children, until they're 18, it's modifiable based on a change in circumstance. In the second half of the talk, we're going to be discussing modification. All right. So bear with me on this because I didn't know how this was going to show up on the screen, but I thought it was really important to take a look at the documents, because different from a custody and parenting time order, these forms that we get for child support are they're very form driven. And well, so I'll circle back to Craig's question. So Craig, if the mother has state aid, then you won't be able to deviate. The child support formula will have to be followed, at least in the counties where I practice. So the only way to deviate would be for the mother to no longer be on state assistance. Both parents have to be off. Well, it's not the parent, it's the child. The child can't be on state assistance. But coming back to these forms are, you'll get a child support recommendation and it may not make any sense. So I'm going to try to walk you through how to read it, but the way it's going to present may not be very clear. So you may want to come back and watch this later, pause it, really dive in. So what I've got here is it's a redacted support recommendation from one of my cases. And it's 4 pages long. These are the first 2 pages. So this is what you would typically get from the front of the court saying, we've reviewed your income, we've reviewed your health insurance, your child care info, etc. This is what we're recommending for child support. The very top portion up there, I don't really have a cursor, so I'm going to point. You'll see the sections where it says plaintiff and defendant is the intro. It tells you where the information come from. Okay, so this is the income. Where do we get it from? We got it from pay stubs. We got it from tax returns, these dates. So the cover sheet to the calculation will tell you the income sources so that you can know what was reported. The child care verification, who that was submitted from. And then you have this grid, and that grid gets carried over into the child support order we're going to look at next. So at the very top of the grid, what you'll see, let's break down the grid. On the left side, you'll see the categories. So you got child support, which is base support, just looking at income and overnights. You're going to look then at the healthcare premium adjustment, and then ordinary healthcare. I'm going to explain what that is, child care, and then if there's any other expenses, those would also be listed there. And then you end up having in the grid, depending on how many children there are in the case, different rates. So you have a 1-child rate, a 2-child rate, and you'll notice that from 0 to 1 and 1 to 2, there's a big jump. So, there's a lot of like the household needs, right? You got utilities, rent, things like that. that's going to be no matter how many kids are in the home, for the most part. There's a big jump from 0 to 1, and then it's incrementally smaller from 1 to 2, 2 to 3, 3 to 4, etc. But in this particular case, you can kind of see. In this case, the payer of support is covering the children's health care, and they are getting credit by the parentheses, which is a negative number, for a portion of that premium that's attributable to the children. So the base support is reduced by $60. Then the ordinary medical is, I'm going to talk about a little bit later. We'll put a pin in that one. And then the child care expenses, you can see, is really quite large and makes up the bulk of this. And then underneath, the second paragraph talks about if there's any arrearages and you're behind in support, how are those going to be paid? And then the next section is what the parenting time schedule is. So how many overnights one has versus the other, which factors into that amount. And then which parent is going to be responsible for carrying the health insurance. Over on the second page to the right, we have the first page of the calculation, and you can see the breakdown from that grid listed at the top. And then we're looking at all of the income and expense sources. So you're looking at the income levels that are reported. There's the medical expenses. There's childcare, and then you can see in this particular form, you can see that there's a percentage, 46% under the left column and 54% under the right column. And taken together, that's that whole, right? So if this family were intact, then the plaintiff on the left at the time was bringing in 46% of the family income. So that percentage is applied over and over and over again throughout the formula, as they're responsible for meeting 46% of every expense related to this child. And then the other parent is expected to meet 54%. So that gets applied to the health insurance premium. That gets applied to the child care expense. That gets applied to the out-of-pocket medical expense. So that percentage amount is really important. On the third and fourth pages here, we get into the different sections of the calculation. First is the children. Are there the children in common here are 2? Do they have any other children from any other relationship? No, that's 0. If you have additional children, those would show up here, and then there would be a reduction for of that total support amount based on those additional children having needs. The next one is so we're looking at net income, and so the front of the court, the child support formula, considers gross income and then manually deducts the expenses. So your Social Security and Medicare, FICA taxes, things like that, that all gets backed out in the formula. In addition, there may be other taxes, local taxes. There may also be some other weird ones, like if you're required to contribute to your 401k plan, that can be considered as a deduction on your income for calculating child support. On the right-hand side, it's so small, I may have gotten no, I didn't. Okay. On the right-hand side, what's that?
I have another question. I'm going to read it to you, but I'll let you finish your thought.
Oh, okay. Man, let me get through this and then I'll pause. There's I'm going to skip the top part of that. We'll get into the healthcare breakdown. So this is the expenses, the health insurance premium adjustment is there, as well as the out-of-pocket medical expense amounts are determined there. And then at the very bottom, we have the child care expense as well. And I realize now I didn't redact that section. But the proportion of the child care that's attributable to each parent, A or B. So this is what you're going to get in the mail if front of the court runs a recommendation and sends it to you. So hopefully that helps understand a little bit what each one of these sections means, because that's what's going to derive what your child support obligation is in the order that we're going to look at next. So James, fire away with the question.
All right, so we have a two-part question. Why does child support make parents pay child support when the child is in the home with the parent, but siblings are still with the other parent?
Could you say that again?
Why does child support make parents? So if I guess they're asking if one parent has siblings and then the other parent has the other siblings, how do they determine who pays child support?
So if you have a situation where it sounds like you got maybe 3 kids, one's living over here, two's living over here, there's a way in the formula to say, okay, we've got 2 living with this parent, 1 living with this parent, and you end up getting 2 different child support recommendations. And then depending upon, what that number is at the bottom of each of those, the difference is, taking the difference, that would be the net child support payment that has to be made from party A to party B. I will also say that one catch here is whether or not the friend of the court actually knows that the children are living in different homes. So what really matters, and this is going to be kind of the talking point at the end, like it was the talking point at the end of custody and parenting time, is if your situation has changed and your order has not, you have got to do something with the court to get your order changed to reflect the new reality. So people do things all the time outside of their court order. And if child support is being done through income withholding, it's coming out of your paycheck automatically. They're not going to know without a new income withholding order being issued from the court that there's been any change. So it may have been and I don't know, it may have been a situation where all 3 were living with one parent, and then 1 or 2 of those kids came to live with the other parent, but that first parent is still paying the other parent as if there were 3 kids there. That's very likely the result of not having gone to court to get that order changed. So very, very important that if things are only for a temporary basis, probably don't need to adjust it. But if it's a new reality that's different from the reality, for your custody and parenting time and child support orders, go to court. And it doesn't mean you got to file a motion. It may simply be that you and the other parent go together to sign what's called a stipulation, which is an agreement saying our reality has changed. This is the new reality. Sign off on it. Your judge will sign it. And now it's a new order. If everybody wants to agree that this is the situation we're in, it doesn't have to be, file a motion, have a hearing, rack up a bunch of legal fees, take a lot of months of time. And the friend of the court is always welcome to people coming in and drawing up these agreements so that they can make all of the pieces match the reality that you're living in it. So was there another part to the question, James, or was that it?
Yes. The other part to the question is, why is it that when mom is getting government assistance, the child still doesn't get the full child support payment?
So I guess the question for me would be, how is the child, is this a matter of whether or not mom is spending the money on the child? Meaning the child is not actually having so many dollars a month being spent on him or her for basic needs. I'm not entirely sure. If you're getting state assistance, it just means that the formula has to be followed, and then the money just goes from the paying parent to the recipient support.
I think this may be about state reimbursement, because the entire payment doesn't go to the recipient, right? Like the state.
Yeah. So right. So I'm going to talk about that. Let's put a pin in that, because I'm going to talk about the DS case, which is usually when this comes into play. I'm going to talk about that in a little bit. So we'll come back to that question.
And Craig had another too. I don't know if you want to his now or not.
Yeah, fire. If the father covers 250 nights, I'm assuming it means the father's exercising, 250 nights, pays the healthcare and daycare when the child's with him, but the mother still gets state aid for food and daycare when the child's with her. Well, yeah, I mean, this may be one of those situations, Craig, where, and this is a common experience with parents have equal parenting time. There may still be an order for child support, even though there's an equal parenting time arrangement. If one parent is making more money than the other parent, then that payment still has to transfer. So I don't know what your income level is, Craig, relative to mom's, but even at, exercising over 2/3 of the year, but mom, again, mom having state aid for the child that may still require, if you're making significantly more money than she is, a payment of child support from you to her. Now, I'll be honest with you that our courts are generally, if you're within a certain amount, they might waive it. If it just seems very clear that the overall goal is being achieved, that the parents are getting along, the child's needs are being met, that there is some flexibility there. But I think just as a general rule of thumb, when there's state assistance, I would be surprised if a parent has 2/3 of the year and is still paying the other parent child support under the formula, because there would have to be a significant discrepancy in income, but there could be to make it go literally that way. Because usually, right, the general idea usually is that the parent who has the child the majority of the time is going to be receiving support, but not always under the formula. All right, so moving on to reading a child support order. So using that recommendation, pulling it into the formula, then you'll get a reference in any order for custody and parenting time that basically says child support's going to be ordered pursuant to the UCSO C attachment. And that's what this is. This is the Uniform Child Support Order that is the order form of the recommendation. You're welcome, Craig. So people don't freak out. Don't freak out if you get a recommendation and you're like, oh my God, like I'm going to get, this is what I'm going to be ordered to pay support. No. That cover sheet will tell you, you have 21 days to file an objection to that. If you don't do that, then yes, it will become an order. It will become this. But the key thing is, if you get that recommendation and you want to have a hearing on it because you disagree with it, either the inputs don't look right or something, you need to file an objection, because that's not the order. This is the order, right? So this is when you get this is when your child support order is now in effect. So at the top, we have the information of the parties, the source of the income of the parties, and then we get down to that grid on the next page, actually, but how many kids are involved, what's the overnights with the other parent, the effective date at the very bottom. So hopefully in most cases, you're getting a recommendation, you're getting an order, and the effective date is sometime in the future, because it's going to take several weeks for this order here to actually hit your paycheck, such that you're being given credit for the support you're paying the other parent. But not always. Sometimes the effective dates are in the past. And if they're in the past, that means that as soon as it takes effect, you're going to have yourself a nice massive arrear, and you're going to have to start working on how to pay that off. So there's the order issuance date, but then it's the effective date at the bottom of this first page that's going to determine when your child support is going to be starting. On the second page over to the right, we have that grid that was pulled from the first page of that child support recommendation. We have there the percentages of what mom or dad pays and the other mom or dad pays. And then we have this annual ordinary medical amount that I'm going to talk about in the next slide. But that percentage we talked about of family income, it shows up here. Post-majority support, that's where this second arrow is. We're going to talk about that. If the child's still in school after they've turned 18 in high school, Then the very next arrow, you've got which parent is ordered to pay or provide health insurance. And there's always a limit that you only have to do it if it's going to be 6% or less of your overall income. But it has to designate which parent is going to be responsible for that. And then, and I can't see because of the question. Let me go back here. I got them both. Thanks, James. And then at the very bottom, I want to talk about retroactive modification, what that means, because it's not available except in very limited instances. We'll come to the question in just a second. I'm going to move on to pages 3 and 4. We have a lot of stuff in here about you need to maintain your address, keep your address and employment information current with a friend of the court. If you don't, you could be in violation of a court order. The next two have to do if there's a non-parent that is providing care and custody of the children, either in foster care or a guardian, that the court can redirect that child support to the person who actually has the child and is caring for the child. And then there's the review language, and we'll talk about that a little bit later, whether or not there's any other provisions, and then the box, if we're going to agree to deviate, you would check that box, and then there's an additional 2 pages that you would complete that would give the court the reasons why we are deviating from what the child support formula would say. So James, could you bring up that question? Berrien County told me that if I ever take my son's father off child support, I couldn't get it back if I needed it again. Is that true? No. I'm trying to put it through my head why that would be true. So again, like coming back to the original first screen I had up, you can't waive child support, or I'm sorry, you can't waive your rights to being a parent. Maybe it wasn't on that first one. I'm going to talk about that in a little bit. You can't agree to reduce parenting time to 0 and child support down to 0. It may not work. I'll just say that. You can try, but it usually won't work. But in terms of taking somebody off child support completely, no, because a parent's obligation to pay child support, as I said at the beginning, it still remains in some cases, even when their parental rights have been terminated. So I wonder if that may just have been a misunderstanding about what they meant, or what you meant when you heard take him off child support. But no, I mean, the short answer is no. Child support doesn't go away completely until a child is aged out of the system. So some highlights on that child support order that I had up earlier. So again, so that uninsured healthcare expense, the support order includes a per child annual amount that is applied ahead of time at the beginning of the year. This is what an average parent can be expected to spend out of pocket on their kid for medical expenses. It's gone down. Last year, it was $454 per child. Now it's $200. That doesn't make any sense to me at all, because the cost of medical care has gone up. But what that means is that before, so that healthcare, if I go back here, this line where it says ordinary medical, that's that amount. So this at the very top there, under subtotal on the right-hand side, ordinary medical is the paying parent's responsibility of meeting whatever that annual ordinary medical expenses for the year. So, what that means, the idea is that they're trying to avoid parents going to the payer of support on January 1st to say, our kid just had an incident at the doctor. I got a copay and I need you to pay your 54% to me. This is a way to sort of minimize or put that off until as late as possible, so that the recipient of support in a case when there's 2 children has to pay out of pocket $400 before they can go to the other parent, the payer of support, and say, I need you to contribute your percentage share of the medical expense because it's already been added into the formula and being taken out of your check and sent to the other parent, your portion of that first $400. I hope that makes sense. It can be a really confusing concept, but if you think about the idea behind it is so that parents don't have to go right away to the other parent to say, I need to get more money from you, because that is never received well, usually. They build in this ordinary medical amount that gets added to your base support amount every single month. Post-majority support, this is a hotly contested issue. And frankly, it's even more confusing now because more and more kids are being homeschooled. But a child's inherent right to child support ends when they turn 18, unless they are still enrolled full-time in school and living full-time with the other parent. Full-time in school, what does that mean? Full-time with the other parent, what does that mean? It can go up to the child being 19 and a half years of age at the most, and then it stops completely. But this is for that situation where your child maybe started school late and is now, going to be in high school past the age of 18. Healthcare coverage, as I said before, it assigns which parent is carrying health insurance, and if the other parent is carrying it for them, but they're not ordered to do so, you're not going to be given credit for whatever you're paying out of pocket for your health insurance for your kid. And then retroactive modification is not permitted under the law unless there's fraud, meaning that you can't go back in time because that money's already been paid out. If there's something wrong, if you need to change your order, if you need to challenge the recommendation, do it now. Do it right away. Don't wait, because you can't go back in time. For example, the situation maybe earlier where one, child is now living with the other parent, but that parent is paying support to the other parent where the child just came from. If you keep paying and paying and paying, and then you're like, oh, I need to go get child support stopped, you're not going to be able to get that money back unless that other parent gives it back to you. The idea, again, being that if your situation is changed, your responsibility is to go to court, either together or on your own, and file a motion to get your order changed to reflect your reality. So retroactivity is rarely ever granted under the law. Was there another question, James? You had unmuted. I didn't know if something came up.
There was another question about interstate cases.
Oh, those are tricky. I should have put that on the list of the things that I'm probably not going to be able to cover tonight. Mm-hmm. The ultimate reality is wherever that state order is out of, you got to go deal with it there. If everybody's in Michigan now, move the case to Michigan. But that's really about all I can get into on interstate stuff tonight.
I will add too, the child support handbook also has a lot of answers you might be looking for. So if something isn't covered here tonight, you can always reach out to Blair or send me your question. I can forward it to him, or you could grab one of those handbooks from the Friend of the Court office or at the Pillar Center.
Yeah. That I talked about that last time, and it's also on my warnings tonight, my lawyer tips. Get a copy. This is Berrien County's Friend of the Court handbook. Get a copy. This has got 36 pages of information that can be really helpful because they explain a lot of things. I mean, I went to school for this, okay? I've been doing this for 10 years. I don't expect the people who come into my office going through a divorce for the first time in their life to understand any of this. And so, having a handbook, and this is why I do this stuff, so you can begin to understand what all these terms mean, what your rights are, and the Friend of the Court handbook is a terrific resource as a first place to start. So definitely do that. So how do I modify child support? To modify an existing order, just like we talked about with custody and parenting time, got to file a motion, allege a proper cause, change in circumstance. In child support, it might be, I lost my job, or I think the other person got a new job. I know they got a new job, or I have another child, or I have to go overseas and be deployed, or my expenses for this child have been diagnosed with a serious medical issue has gone way up. Those are all good reasons to file a motion. It goes to the other parent. A hearing gets set. The friend of the court then will send you questionnaires to complete. Do that, because they can't do a recommendation if you don't provide complete and accurate information. Now, obviously, if you're going after the other person for more money, they may not want to submit their stuff in. But there's things that you can do, and probably in a situation like that, you're going to need a lawyer because you may need somebody who has subpoena power, who can get information that isn't voluntarily going to be turned over. But eventually, you'll get another one of these recommendations, and then that recommendation will be made available to the court. And at the hearing, you can deal with the issues that you might have there. The court will consider the evidence and issue a new order if you've met your burden of proof. And like we talked about last time, if you disagree with that, you can always take it up to the judge, because these hearings are always heard by attorney referees, not judges, but they feel exactly like they would feel like you're in court with a trial and everything like that. So that's the process side of filing a motion. But what do I have to prove? Where might I stumble? What are the issues I'm going to run into? What issues do normal people run into? One of the big ones is irregular income. So if you work seasonally, how do I show, if I'm working 9 months out of the year, but now I don't work in the winter, so how, I don't get a regular paycheck. Well, what do I do? Well, what they'll often do is ask for 3 years worth of tax returns to see what your reported income is to the IRS. A big area of conflict is self-employment, right? So I'm self-employed, and I have the ability, being self-employed, to manipulate the numbers, right, to a certain extent. It's a lot easier, right, to basically take two salaried employees or two wage earning employees. You get the pay stub from their employer, from ADP, wherever it comes from. Those numbers are hard to argue with. But self-employment, starts with tax returns and schedules. But in some cases, you may need to hire an expert to really dive into the profit and loss statements, the balance statements, see where the money is, see if it's being hidden. Some deductions for tax purposes are added back as income under the child support formula. And I will caution you to say, listen, when you got somebody who's self-employed, don't try and get the exact number. You're never going to know. And it's always a challenge, especially if you were with them when they were working. I know they're getting paid under the table, yada, yada, yada. It's very difficult. It's just a reality. It's hard to deal with. Try to live with a number that feels good enough, right? There isn't going to be an exact number when you're dealing with somebody who's self-employed. Another big issue is voluntary underemployment or unemployment, right? Somebody's choosing not to work or choosing to work less than full time. So the workaround for that can be imputation. And there's a whole section of that in the formula that says when a parent is not working or has the, quote, unexercised ability to work, then they can be imputed at a certain level of income. Now, at a minimum, they can be imputed at unskilled minimum wage work, $10.65 an hour, 30 hours a week. That's what it is right now. It's going to go up in a couple of months. Also, though, if a party has left a job without good cause or been fired from a job based on their own malfeasance, they could be imputed at that former job, right? So one of the things to look at is, listen, you're trained as a nurse, but you're working at McDonald's, and unless there's a really good reason for doing that. Now, some of this is sort of self-motivating. People want to make enough money, not just necessarily to be, have to pay so much child support. But, you can impute somebody at a former level of employment if there's a really good reason under the law to do so. The other thing to consider is in-kind assistance. So if somebody is providing a parent free housing, they're not having to pay rent because they're living with mom and dad, or they get use of a company car or a company phone, then they're not having to spend that money on those things. And there's a provision under the formula that says we're going to put a dollar value on that and consider that as income. So it's basically you're getting gifts, right? And the formula says some are okay, but some are not. And a big one is housing, right? So we're gonna add in what a reasonable housing expense would be and treats you as if you are earning that amount on a monthly basis. So other notes on modification, the court doesn't have to follow the parenting time order that's in place. For example, if a party is awarded 90 overnights in their parenting time order, but they're only exercising 15, the court can order child support based upon the actual exercised overnights without modifying the parenting time order. Now, usually they're done together because somebody has filed a motion to modify parenting time, but they don't have to. In other words, the idea is that we're trying to mitigate the financial differences between the homes. So if this child is over with the recipient of support way more than what the child support order initially contemplated or the parenting time schedule contemplated, they can adjust child support under the formula without changing the parenting time schedule. There is a floor on this. It says if your new order is going to change your child support obligation by $50 or $10 or 10%, whichever is greater, we're not going to mess with it. It's just not worth the time for us to change things. So if that modification is only going to have a very minimal change in the actual amount, they're not going to change it. Then there's statutory review, which was indicated on the child support order at the very end, that if neither party files a motion after 36 months have passed from their current order, the friend of the court's going to automatically conduct a review because there's a good chance that something has happened in 3 years, either a housing change or a job change or a new child or something. And so we're going to reevaluate that child support whether anybody asks us to or not. Now, in my experience, it doesn't always happen at 3 years. Sometimes it doesn't happen at all. Can't tell you why that is. It's just something that I've seen. So if you need a change or there's a good reason to change, you can file the motion. Don't wait. So how long does this whole process take? Just a couple hours to fill out the forms, 3 to 4 weeks for the other person to respond. You get your hearing date. That happens about 1 or 2 months after you file. That hearing is relatively short, 1 to 3 hours maybe at the most. Now, if you have self-employment and a financial expert, then that can get pretty lengthy. But most child support hearings take about an hour. And then you might get a decision. You probably know that day, but you won't actually get the order for a couple of weeks. And then again, you have that appeal period. So these things move a lot faster than custody and parenting time motions. Though, as I said, a lot of these motions are blended together. So, if you file for custody and parenting time, if you're going to change parenting time and you want to change it from equal to reasonable rights for the other parent, then child support is automatically going to be added to the docket because that change is significant enough to affect support. And that right to support, again, is the child's. So we're going to make sure that the child's needs are met by considering child support as part of your parenting time modification motion. So the DS case. So DS is a code, right? It stands for domestic support, and it's often initiated by the prosecuting attorney. And typically this involves parents who are unmarried, children born out of wedlock, but it can occasionally involve parents who are still married, but they're living in separate housing, and usually springs from the custodial parent applying for state assistance. So when they put the application in for the child to be on Medicaid or to get food stamps for the child, then eventually that will get rerouted to the prosecuting attorney's office, who will file a complaint or a motion on the recipient of support's behalf saying, we need support to be paid by the non-custodial parent so that the state of Michigan can be reimbursed for a nominal part of the medical expenses that they're providing. And back on that earlier slide, you'll see that out-of-pocket medical expense, we're talking about pennies on the dollar here for what Medicaid is covering for doctor bills, hospital bills, ER bills. And yet, the law allows for the prosecuting attorney's office to intervene on the state's behalf to get child support charging. And so that medical amount, like we were talking earlier, that medical portion of that full child support grid, that doesn't go to mom or dad. that goes to Lansing. So they're only going to be getting whatever that base support is. And then if they're paying for childcare, they might be getting a childcare subsidy as well. The way that these DS files work is that because custody and parenting time is married to child support, the parties have to reach an agreement on custody and parenting time in a DS case. DS meaning the goal is here, we want to get child support. Custody and parenting time is an afterthought for us. That's kind of what the mentality is. If you can't reach an agreement on what the parenting time schedule or custody is going to be, then you're going to be going to a contested hearing, at which point the prosecutor will step out and wait for the results. Typically, the prosecutor meets with both parties. What do you want? What do you want? And see if you guys can reach an agreement. They'll send out a consent order. But if you don't have an agreement, you're going to have to go to court to get it resolved. If you receive a summons and complaint for a DS file and you don't respond, you're potentially going to be held in default, meaning we gave you the chance to respond and you didn't. And they're going to enter an order against you on whatever terms the prosecutor and or the custodial parent want. So don't ignore or avoid anything you get in the mail from the court. I got to tell you, it's how many times I've had people come in here and they've missed their deadline to object, or they're in default and now they're trying to modify because they didn't want to fight, they weren't ready, whatever the case may be. It's only going to cause you problems in the future. If you get something from the court, it's important. You got to make sure you do something with it. What happens if I don't pay? Criminal offense. Could be as high as a felony. You don't want to get into that situation. A party can seek enforcement or contempt if somebody's behind even 1 month. Rarely have I ever seen that happen. Usually it has to hit, $1,000 or more, be a couple of months behind in support. But the support order allows for enforcement for just being 1 month behind. It can be started by the recipient of support, but the friend of the court also, as an advocate for the child, can file a motion for a show cause, which means we're asking the court to hold the payer of support in contempt for failing to pay child support. That can result in contempt of court, jail time, suspension of licenses, and understand that the other parent refusing to allow you parenting time is not a defense to pay support. The idea is you got to do it through the proper channels. If you have a right to see your children in a court order and you're not, then you need to file a motion or you need to file alleged denials of parenting time to get your parenting time enforced. Stopping paying child support is only going to make a bad situation worse. And if your circumstances have changed, do something. The court will entertain. Things happen, right? File a motion. You can't go back in time. File a motion so that they can deal with the change in your circumstance right now. Income withholding. So that, I think, generally is a concept people understand, but that's when the court issues a separate order to your employer saying they owe money to this other parent. You need to send it to Lansing, and then that money gets taken out of their check before it even hits their bank account, and it will come out based on the frequency of their paycheck. So like Whirlpool, most people get paid monthly. It's going to come out once a month and go to Lansing and then go to the recipient of support. Some people get paid weekly. Most people biweekly. And so, right, that full amount isn't going to actually hit until the end of the month has reached. So you're going to get portions based upon how frequently the payer of support gets paid when there's income withholding. If it's going to take quite a while, because you got to go from the court to accounting to them sending it to your employer to them processing, hitting your payroll department. So all of these things can take several weeks or a couple of months, but you're still obligated to meet your obligation for support based on that effective date. So know that if you don't do anything, you may end up with an arrears. So it's really important to keep eyes on what your child support obligation is. I'll talk about that later. Just a warning, direct payments to the recipient of support are not considered support. So don't pay them directly unless they go down to the friend of the court and say, I received support and you can get credit for it. Pay it through the Michigan Child Support Agency. Income withholding or not, you're responsible if you're to meet your obligation. If something happens, maybe your employer screws up or something like that. They're not responsible. You're responsible for meeting your obligation on a monthly basis. Income withholding does not absolve you of that responsibility. And then again, my warning about retroactive modification, that if it's paid out under a valid support order, it's gone. You can't get it back. I think I'm doing a little bit more time here. We're going along again. I've got my screen open in 2 places, so let me see how many slides I got left. All right, got a couple more slides. So the child support parenting time tug of war is kind of what I call it. So a couple of examples of things that I hear in some form or another frequently in my 10 years of doing this. Mom or dad wants more parenting time, so he or she doesn't have to pay me child support. So number one, more parenting time, and people don't necessarily understand it, whether that's actually true or not, is that if you get more parenting time, will your child support obligation go down? Yeah, under the formula. But guess what? You're going to be paying more directly to the child, spending money on the child, feeding him, keeping him warm, taking him to do things because they're with you. And more than likely, actually, that expense is going to be a lot more than what you would be paying the other parent, because child support, I mean, to be honest with you, I'm a parent of 2 kids. It hardly covers the thing. I mean, realistically, like most of my clients that I work with are grateful if they get it, but it rarely is enough to really meet their needs. So you're going to be spending a lot more money on your kid than you would be paying the other parent. And there's a difference between the perception and the reality that, number one, is that even true? Do you think it's true? Is that, have they said, even if they've said it, does that make it true? Believe me, people can be real nasty in these cases. And as a mediator, I sit on both sides, right? I meet with both people, that sometimes people will just say it just to provoke, the person that they don't like anymore, the person that they resent, that they now have to pay money to, right? All of these emotional things that can get in the way, none of which is going to help your co-parenting relationship. So I advise my clients to ignore it. It's noise. The amount of child support one receives, I said it already, it just falls far below what you're going to spend. And remember, that child support is the inherent right of the child. It's not the parent. Yeah, you don't have any control over what that parent's going to spend the money on. And I've heard the stories, that they're like, my child's not getting their needs met and mom's out here buying fancy clothes and stuff. Listen, I'm not saying that isn't happening. It's just, I don't think the overall end of it is going to help getting into that mindset, because at the end of the day, most people are having to have a relationship with that person to some extent. Another one I hear is mom or dad isn't going to let me see my child, so they don't need my money. I'm not going to pay them. The appropriate remedy, again, is seeking enforcement of parenting time or establish parenting time. If you don't have it, get an order that says this is, again, you're only paying child support because you've been legally determined to be a parent, which means you have a right, except in that rare instance with parents whose rights have been terminated. Almost everybody else has a right to parenting time, and their kid has a right to parenting time with them. So if you don't have any parenting time in a court order, go to court and get some. I'm not making it sound super easy, but I mean, that's the step to take. Another one, is, since I can't see my child, I just want to sign off on my rights, right? And the underlying kind of theme there might be that I just want to avoid paying support. I don't get to see my kid. Why should I have to support this kid? Remember, whether you liked it or not, or chose to or not, let me take that back, not chose to, but whether you wanted to have a relationship with this person or it was a one-nighter, you made a child, right? You brought a child into this world. And in Michigan, they don't terminate parents' rights unless there's abuse or neglect, or on a condition that there's a new parent or a new custodial figure willing to step in, right? And usually it's step-parent adoption, can be relative adoption. But that's, otherwise they want to make sure that the state has a vested interest to make sure that this child doesn't end up on welfare. They want to have 2 viable parents unless again that abuse neglect concern is so severe, we had to cut off their rights. We want to keep that option available for the other parent, if not to be a parent, at least to be responsible financially for the little person that they brought into the world. So, people, I hear this at least a couple of times a year, not as often. I usually just don't even go there with folks, but I just want to sign off on my rights. And it's sad. I mean, it's really sad to hear. And I think it's often out of frustration. But yeah, it's a double whammy to be paying for a child you don't have a relationship with. But understand that that's not available. It's not going to be possible. So, you got to fight for your right to be in your child's life sometimes. So final thoughts to wrap this up. Appreciate everybody staying on a little bit longer. Is, like I said last time, and we talked about earlier, get copies of and read your court order. Know what rights you already have, because a lot of people are walking out there with rights that are unexercised. And I said before, if you don't use your rights, you're going to lose your rights. Get copies and read the front of the court handbook. If things change in your life and your ability to pay support or your need for support is greater, file a motion, take action, check online or with the friend of the court on a regular basis to make sure that you're square on your order. Make sure that you're meeting your obligations. You can pay your support online or the friend of the court office, but a lot of the stuff is available online now, that you can check your order in real time and see, am I behind? Am I current? What's going on there? But definitely, again, you want to pay your support through the system, not directly to the other parent, because it's going to be considered a gift if you do so. So Craig's question about much difference between Berrien and Cass. Yeah, I mean, there's not a lot of difference, but every county is slightly different. Cass doesn't have friend of the court investigators. The formula is the formula, whichever county that you're in. But in Craig, your situation earlier, I think again, really it's understanding, about what's the goal here. If the child is well cared for and the parties are meeting their needs, then I think there may be some wiggle room there to be able to opt out. I will say, if I can recall, but I don't think it's as much a rule of thumb or a policy in Cass County that when state assistance is involved, we're going to follow the formula. In Barry County, it's a pretty strong policy, but I don't think that's the case in Cass County. But every county's front of the court offices and how they interact with folks and the resources that they have available is pretty different. So you're definitely going to want to check out Cass County. So that's what I got tonight on child support. Unless there's any other questions, I know James has got a hard stop with us tonight, Mr. Theatrical. So we don't want to hold him up because break a leg, James. Break a leg.
Thank you. Thanks again, Blair. It's very informative, I should say. Like you just said, I'm about to actually hit the stage in about 12 minutes. So if no one else has any other questions, we're going to call it a night. Really appreciate everybody that came out, everyone that had questions for us. As we said before, make sure you grab that Friend of the Court handbook. My email address is jgunser@presentpillars.org. Blair can say his.
Blair@blairjohnson.law. And don't forget, we got 2 more months of this. Next month, we're going to be doing paternity. And then the last month, we're going to do guardianships. But we might just keep it going. We might just keep going on all kinds of new things because there's a lot of stuff we didn't cover, even in child support land.
Plenty. Even for those who are experiencing deportation and things like that, I know some people had questions about those types of things. So if you got any questions or a topic or suggestion for a topic, please let us know. You can email us, give us a call, and we'll be happy to help. Oh, here's a good one. I like that. You've helped me a lot when it comes down to it all, and I'm doing great now. That's good to hear, Cam.
Excellent.
We'll catch up sometime.
Good.
Yeah.
Well, thanks all. Look forward to seeing you again next time, and thanks, James, for the opportunity.
Absolutely. Thanks, Blair. Good night.
Good night.